All right, everyone. We want to welcome you here today to this webinar on trust basics. It looks like we still have a few people that we're just waiting for to join. So we'll give everybody a few minutes and then we will get started. I will just go over a couple of things before we get started here. So for everybody, we are going to be recording this. A copy of the presentation along with the slides will be provided to you within 48 hours of the presentation. If you are getting CE credit for this, there is a handout that you can download. And if you'll just submit that within 1 week, we'll get those turned in and you'll be able to get your credits. For questions in your chat feature, if you want to send any questions throughout the presentation to me directly, you can do the drop down and just do organizers only. We will monitor those questions throughout the presentation and we will have 5 to 10 minutes at the end to answer a few questions. So to kind of get started here, I'm going to do a little introduction of our speaker. Our speaker today is Fran Damaris. She brings with her over 3 decades of experience in personal trust, estate, and guardianship administration. She's a former vice president and trust officer of Champaign National Bank, as well as a faculty member at Cannon Financial Institute. Her technical expertise has earned her invitations to speak frequently across the country at meetings for trust, audit, compliance, and risk management organizations. She's also currently a member of the East Central Illinois Estate Planning Council. Here. Fran, I'm going to turn the time over to you now. Let's make sure you have the keyboard. Can you see that, Fran?
No, but I can use my other equipment. Good morning, all. This is Fran Damaris. I am simply delighted to be with you today. This is a very basic introduction to trusts, and as a result of that, it may be that it is more basic than you were expecting. But please bear with us if you enjoy this presentation, because we have intentions of doing more and more detailed things as we move forward. Also, if there are topics you would like us to speak on, I hope that you would include those in any comments that you make as we go forward. So without further ado, let's move. The first thing to understand is that my enter key is not working. Oh, there we go. A trust is an account that's either managed by an individual person or an entity, and it is managed for the benefit of another, and it has a variety of elements. Its primary concern is that it is a fiduciary relationship, which means that all decisions made by the person or the entity that we refer to as the trustee must in fact be made in the best interest of the trust and the beneficiaries, and dependent upon what the document language gives us as direction. So it's sort of a trifecta of things that has to happen. So in order for us to have a little bit more of a conversation, I think it's important for us to first have some definitional understandings. So we refer to the person who establishes a trust as a grantor, and there are lots of other terms that are used as well. My rule of thumb says if it ends in OR, it's number one, the person with the assets. And so that would be the grantor, the trustor, the settlor, the donor, or the creator. Once in a while, someone likes to call them a maker of the trust, and that's okay with me, but it doesn't meet my criteria of ending in OR, so it's not one of my favorites. I would suggest that the words settlor and trustor are very old-fashioned terms. And so although they absolutely are representative of the same concept, I think that in today's world, people talk a lot more about grantors of trusts or donors of trusts. A grantor of a trust might be an individual who's setting up a trust exclusively for their own benefit. That trust we call a revocable living trust, which we'll discuss in a minute. We also might think of a grantor when someone's granting a gift to charity or others, but that's also where the term donor sometimes shows up. So the person who is the grantor, trustor, settlor, etc., is by definition the person who has the assets and will set up the trust. So they have several responsibilities, not only the funding of the trust, but also selecting an attorney to draft a document that meets the needs that they specifically have. And recognize that our needs over our lifetimes change fairly dramatically from when we're first in the workplace till when we're perhaps building family units, to when we are trying to educate children, to when we are empty nesters, to when we are in retirement. So oftentimes a trust will extend for 60 to 120 years, and it often extends even longer than that. So this document needs to have a degree of flexibility built into it. So the selection of the attorney is an important job that the grantor is responsible for. And sometimes grantors don't necessarily understand how important that job is, because recognizing that we want someone who is fully acquainted with all the terms and conditions that might be necessary means it's nice to have a specialist. Many people hire attorneys for a specific purpose, like the settlement of a house or a divorce. But that same person may or may not be the right person to draft a trust. So one of our jobs is to try to help clients recognize that estate planning is a very finite field of study, and it, like doctors, attorneys like doctors, often have specialties. The trustee, I've already mentioned in passing, is an individual or an entity that agrees to serve for the grantor and the beneficiaries of the trust in making certain that the terms and conditions of the trust are met. So we follow the document, but we also do it in that fiduciary capacity that I mentioned earlier, making all decisions in the best interest of the bennies based on the document we've been given. So when you are a trustee, by definition, you will have a fair element of discretion, but understanding how important it is to use a fiduciary standard in that discretion is what sets this particular relationship apart. A beneficiary is the party who is going to benefit, therefore the name beneficiary, the beneficial interest holder in the account. And in a revocable living trust, the benny may be the same as the grantor. But in other sorts of trusts, the bennies may be family members, spouses, or children. They might be charities, which are the beneficiary of some trusts. And also, beneficiaries come in different flavors. The person who receives the income from the trust on an ongoing basis is often referred to as the income beneficiary. But Oftentimes, an income beneficiary only has an interest for a period of time, and that period might be set as a time, 5, 10, 15, 20 years. It might be set by their lifetime. It might be set until an event occurs that changes things. But when the income benny's interest ends, there may often be what we call remainder bennies. And there's a term from old math. I think even in new math, we still have remainders. So if I start with a pot of gold, and that's invested for an income benny over his or her life, but when that benny dies, perhaps the surviving spouse, it's going to move on to the children of the marriage. The children of the marriage might very well be the remainderment. So if we go back to, just momentarily, the responsibilities of a trustee, it's to manage that portfolio in the interests of the beneficiaries, both income and remainder. So rarely will you ever see a trust that is fully invested as a fixed income vehicle. Instead, it generally has an element of income and an element of growth. And how that's divided depends on any number of things. In order to have a trust, you have to have corpus or principal or property. And property can be real property or personal property. We like to have a variety of assets in a trust, but we are best at managing investable assets because those are things where we, as trustees, can bring the greatest benefit. A revocable trust is just what it sounds like it is. It's a trust that can be changed, amended, altered, or simply canceled. One of the loveliest things about a revocable living trust set up by an individual for themselves and using often a corporate or other trustee is that if they find they don't like the way the game is being played, they can simply take their marbles and go home. So realistically, you're not locked in forever anymore than when you are a financial advisor. Your clients are locked in to the relationship you have. The relationship you have builds and develops and tries to encourage a client to meet their greatest expectations. And as long as you're serving them well and doing a good job for them, they will not want to replace you. But in the same way, a trustee who is not doing the job in the way that a revocable trust wants, those people have the right to remove that trustee and change it. So revocable trusts are pretty exclusively revocable living trust, a trust established by a person for themselves and their families. However, revocable trusts become irrevocable trusts at the death of the grantor, and that seems logical if you think it through. That person set the stage not only for his lifetime, but perhaps for treatment for him during incapacity, and then ultimately what the assets should do at his death. Since they're his assets, he makes that decision, or she. Additionally, at that time, the trust is no longer revocable. So an irrevocable trust is just what it sounds like it would be, a trust that sets its terms and cannot be modified. Now, that is a factual statement, and that is the way we want clients to look at irrevocable choices, because they should understand that they can't change their mind over time. But as a professional, you and I need to understand that a court can, in fact, change an irrevocable trust. And it happens most commonly when the trust no longer serves the purpose for which it was intended, if the purpose that it was intended to cover has now passed, or if the trust becomes so small as to not be appropriate to the task anymore and to be too costly to run. So there's a variety of circumstances that you can envision where an irrevocable trust will in fact be changed. When I was working with clients on a daily basis, I had a family, and it was a husband and wife with 2 children. And they had set up a trust to support grandchildren's educations. And one child had married rather young, had children right away, and those children had already enjoyed a college education and were often on their own. There was a slightly younger child who married late, had children later, and so his children were still quite small. Unfortunately, in this story, that gentleman, his wife, and his children were all killed in a horrific accident. And so, although we did not approach the grandparents right away, we spent a little time to let them grieve. And then we went to them and said, the purpose for which you set this trust up has now really been met. You have well educated the grandchildren that you have, and the others will never be able to enjoy this. So the ultimate distribution of this is to go to your grandchildren, and it appears to us that they are mature and responsible adults. And although you set a date in the trust that would be the final date where if a child had not received an education, the trust would still distribute to the beneficiaries. And that date is far out because the children in the accident were very young. But it seems to us that this has met its purpose. And we were wondering if you, as the grantors of the trust, would like us to petition the court to distribute the balance of the principal to your other grandchildren, which they were very pleased about, because that way they got to see the grandchildren that they still had enjoy that part of the trust, and it allowed their other grandchildren that still remained to actually buy houses and move forward in their lives a bit faster. So that's an irrevocable trust where the purpose of the trust had actually been met, but the terms of the trust would not have paid it out. So sometimes there are circumstances where something that's irrevocable can be changed, but it must be by the court. I always laugh when we put taxes on here because I think everybody knows about taxes. But for the most part, the largest majority of people in America know about things like income tax, whether federal or state. They know about personal property tax. They know about sales tax. They know about real estate tax. They know about a lot of kinds of taxes, but not all of them are aware that there are also what we call transfer taxes, gift taxes, estate taxes, and generation skipping taxes. And those are taxes that overlay a lot of the planning that occurs in a trust. So I just want you to understand that when we talk about taxes, we try to be very specific about the type of tax that we're going to discuss. But many of the trusts that have been established over the long term in the world of trust have been established actually based more on transfer tax than probably most other taxes. Okay, I'm still not able to do this, so I have to ask you to move the slide for me. We've suggested that there are 5 most common types of trust, and the first is a living trust that I've mentioned several times. There are also some charitable trusts. There are charitable remainders and charitable leads, often referred to as split interest charitable trusts. And although they can both be very effective, the charitable remainder is used much more frequently than the charitable lead. In addition, we have testamentary trusts. Testamentary is the opposite of living. If a trust is established under your last will and testament, so when you die, we refer to it as a testamentary trust. Just as when you do it in lifetime, we talk about it being a living trust. And the other term for living is the term inter vivos. Inter vivos is a Latin term, and the law is still pretty laden with Latin terms. So in the world of trust, we sometimes use that term as well. Irrevocable life insurance trusts, which many of you who may sell life insurance would be familiar with, became very popular in about the mid-'80s, and they have served for many people over a very long time. At this point in time, they probably are used slightly less, simply because the exemption equivalent amount, that amount that I and each of you are entitled to pass at our death, has gotten to be so enormous. As of 2020, each of us who are US citizens and permanent residents of the United States can in fact transfer $11.58 million worth of assets in cash or in kind, in combination, with no transfer tax being levied. And so because of that unique situation, irrevocable life insurance trusts have often been used by people to either pay taxes that would be due at their death to secure their own assets, which is almost non-existent unless you are ultra wealthy. And it also has on occasion been used to build estates for children, which continues to be a use that's very accurate. The last one listed here is a QDT. I listed it that way because it is a form of marital trust, and marital trusts are a good portion of the trusts that we use. They fall under testamentary trusts in most cases. But the QDT is unique because it is for a US citizen married to a non-citizen spouse. And although that is an unusual situation, it is increasingly common in America, and this particular trust has a way to deal with that very, very importantly. Okay, moving on. A living trust is created by a grantor, almost always, though I've seen people who are parents create a living trust for their child and simply pass the assets and the trust to the child, knowing that the child now has full and unfettered control of those monies. Now, many of us might think giving a child money outright and giving it in a trust would be nearly identical and wonder about the purpose. But if a family wants a child to utilize management of those assets for their benefit at a time when a child might not be well versed enough in financial assets to do the right things, or might not have adequate experience, they might put the money in a trust and have someone managing that money for them over a period of time. That would be the responsibility of the trustee. Now remember, ITCOA does not manage money for clients. We simply use fiduciary advisors who could be picked by the family if chosen, so that they can continue to use someone like you that they trust, while the trustee would in fact do the administrative and other features of the trust. So occasionally that happens. And when it does, oftentimes these parents have many other assets. So they might say to the child, you have the right to take this money and do with it whatever you want, but I'm going to be watching. If you're able to make this money grow and build and become more valuable, then I'll be more likely to want to give you more money in the future. So if you decide to take it out, you take it at your own risk. In addition, living trusts often serve, as I said to you, to give a kind of a three-part trilogy of results. This is what I want you to do with my trust while I'm living. Pay me all the income, or deposit X dollars per month to my checking account, or build this money for other purposes in the future. So it can be fairly directed at its inception. There will also likely be a section where it would decide what should happen should the individual grantor become incapacitated. Remember, in incapacity, you often simply cannot do the things that you've done in the past, and you may need a trustee to step up to pay bills, to renegotiate the way your assets are invested, because over the short term, you may now have a greater need of income than you had previously. It also says that that period of incapacity may be, as we think of it historically, sort of a long, debilitating process that led to death. But in today's world, incapacity often means a period of time where you may not be capable of managing. But because of all the modern miracles of medicine, we may very well in therapies have a chance to come back and fully manage our lives on our own again. And then lastly, this gives you a way to avoid probate and to say where the assets of the trust should go, how they would be distributed, when and to whom. So a living trust is really like a financial life plan. And it operates during active lifetime, very much like an investment management agency. But it has the added advantage of being able to protect an incapacity and protect and establish a new plan at death. So there are reasons why a living trust has become a very popular item. Healthcare and end-of-life provisions can be placed in that trust so that they're available for everyone to see. The protection against incapacity of the grantor or the beneficiaries. You know, in today's world, we have an increasing number of special needs children. And if that happens to be the case with one or more of your grandchildren, that's a real gut-wrenching thing to deal with. But having a plan in place that allows for the assets that would go to that child to be protected in a special needs trust might be one of the very valuable things that you might want to consider in a plan. The elimination or reduction of probate delays and expenses. I guess everybody in America must have some horror story about probate, how much it cost, how long it took, how unfair it was. The reality is, in today's world, probate is not nearly as hideous as it has been at some points in the past, but it is a very public procedure. Anyone who wants to know can go to the local courthouse and find out everything they want to know. They can read your will. They can see when distributions were made. They know who got the money and how they got it and when it went out. And that leads a lot of people to some pretty creative scams. People calling widows and saying, I knew your husband and he really wanted me to have this asset for you, but he died before he was able to complete the transaction. That sort of thing is very difficult for anyone to deal with, but it doesn't happen when you go through a more private approach, which a living trust can allow. Easy succession of trustees. Sometimes we start with one trustee and we want a different trustee at some other place and time. So recognize that that can be a very important thing to certain people in certain situations. Immediate access to income and principal by bennies. Well, let's face it, if I don't know anything about the client that I'm dealing with because that client is died and I or my company was named to be the executor, and he or she had children or grandchildren in college, and they come to the executor and say, I need money for school in the fall. What can an executor say? To a large extent, they have to say, I'm sorry, but I don't have enough information yet about the situation in this estate. So if you want to go back to school in the fall, you'll need to borrow money or find some other resource. And when this estate settles, I may or may not be able to pay you back. But if there is a trust, and I've worked with that trust client over a number of years, and I know his intention is to educate those grandchildren, when they come to me, I already have a full picture of what the assets of the estate and the intention of the grantor are, and I can likely still continue to support that child or grandchild through their college education sort of on a nonstop basis. So understanding how important having access to things can be, dependent upon the situation, can be very meaningful to beneficiaries. And then we already talked about privacy. Many times there will be a filing of inventory in any probate situation, but many states do not require that during the movement of a trust. A testamentary trust, sometimes called a trust under will, is created by a will after the grantor's death. This trust can accomplish the following estate planning goals. Number one, preserving assets for children from a previous marriage. Recognize that in America, a spouse always has certain rights to a decedent spouse's assets. So even if you're involved in a second or third marriage, that surviving spouse of that final marriage will have rights over the assets, but only up to a point determined by law. So knowing that a trust could provide those rights to the surviving spouse, but still maintain the principal of that account for the children of an earlier marriage is something that's very important to a lot of people due to the fact that in America today, we have a lot of multiple marriage situations over a lifetime. Protecting a spouse's financial future by providing lifetime income. Sometimes a surviving spouse is not the spouse in a marriage that was the best money manager of the marriage. If that happens to be the situation in a given person's life, then being able to put that money in trust and create an ongoing income stream that protects that spouse from then on can be very powerful. Ensuring that beneficiaries with special needs are taken care of. I mentioned that in today's world, we manage increasing numbers of what we call SNTs, special needs trusts. And those special needs trusts follow very specific patterns so that if a child with special needs is being granted government benefits to assist in their care, particularly Medicaid, which can be absolutely incredible for the needs of a special needs child, then the assets of the trust under that special needs trust cannot be taken away from that child, but can be used instead, not just for health, education, maintenance, and support, but rather ancillary needs like quality of life issues that will supplement but not supplant the original needs that the child has that are being met by government benefits. And lastly, but very importantly for many people, a mechanism for gifting to charities. And in gifting, clearly, you do not need a trust to do outright dispositions. But if you're trying to set aside a pool of funds that might pay to students in a specific curriculum from your alma mater over time, with each donation to a child who receives it being awarded to that student in the name of the family that left those dollars, that can be very, very important. Also, the things that we talked about earlier, those special trusts established for charity, whether they are charitable remainder or charitable lead, give you a chance to essentially divide the money between charitable and non-charitable bennies. Sorry. Just a minute. I just want to make sure I did this right. Hang on. All right, we are ready to talk about irrevocable life insurance trusts. There is currently, as I said to you, an individual exemption that is set at $11.58 million as an estate and gift tax exemption. But any portion of that money that is not set up is now taxed as high as, and I apologize, this is my mistake, 40%. I apparently didn't proofread this right. It's 40%, not 45, for estates that are higher than 11.58 million. So life insurance can be an invaluable tool in the estate planning kit simply because over time it has allowed for a grantor to establish an irrevocable life insurance trust, often abbreviated as an ILIT, and to fund that with gifts on an annualized basis, which are indirectly gifts to the bennies of the trust. So let's just think about this for a second. If I have a pot that I make with my hand, a little cup, let's say, and I put money into that cup as my present interest gifts to my children, but my children are not going to get it now. They are instead going to allow me to take, in this case, up to $15,000 per year per Benny as a premium in a life insurance policy and put that premium into the irrevocable life insurance trust, which then, instead of directly paying the premium, writes a letter to the child under a theory in law that we call a crummy letter, C-R-U-M-M-E-Y, not named crummy because it's a difficult or nasty or not good power, but because crummy is the family name of the family that came up with the idea. And they said, if we put the money in the trust and the trust sends a letter to the child offering them either all of it or their share of it, if it's proportionally divided, and the child does not take it, it is as though the child has said, oh yes, I see that $15,000 on my behalf, but I don't choose to take it now. I'll let it go as the premium to pay for insurance on my parent or grandparent's life. And it's pretty easy to visualize that if the policy premium is $15,000 per year, and particularly if you start at a relatively young age as a parent, you can buy an enormous amount of insurance as you start multiplying that by multiple bennies. And so this product then allows for the insurance to be purchased, but under the crummy theory, that was given to the child each year under the right of withdrawal. Then when that parent, grandparent, whomever dies, or the second of those two dies, that pot blows up not to the value of the $15,000 annual gifts compounded, but by the value of the life insurance which was purchased. And because at each giving, we have converted it to a present interest gift to the child, it will therefore create no tax as it comes out of the estate. Now, as I said to you earlier, this technique was used by enormous numbers of people when our exemption equivalent, that is now 11.58, was down in the $600,000 range. Because when $600,000 was the maximum amount that you could pass, we came to a point in America where virtually all middle class as well as high net worth clients had more than $600,000 in assets. So these are not as popular because more and more people are simply exempt from ever paying the tax. But it remains a great technique to be able to provide a lifetime of giving to a child, even in periods where the child is very young. Since the island is funded with a life insurance policy, where the trust becomes both the owner and the bene of the policy, the grantor's heirs still are the beneficiaries of the trust itself. For this plan to be valid, the grantor must live 3 years beyond when the policy was transferred into the trust, because there is a 3-year pullback rule in estate tax. But remember this, anytime you start a brand new policy where it is initially owned by the trust and benefits only the trust, then the individual person who buys it has never had any incidence of ownership in the policy, and the ILET policies will simply never come in to the estate. So that leads us to split interest trusts. And we're going to talk momentarily about both charitable leads and charitable remainders. On the smaller linkage there at the top of the slide, I wrote charitable remainders before I wrote charitable leads. I want you to know that I personally am a huge fan of charitable lead trusts. But what I do know is that relatively few of them are established. So the ones that are most prominent in this split interest world are charitable remainder trusts, and they provide a charitable gift of whatever the remaining interest in the pot of funds is at the end of the non-charitable term. So let me show you an example. I had a client years and years ago whose father was a U of I professor, and he was a professor in California. And he was very, very much his own man, and he had done a great job in his own career. In fact, although I live in Champaign, Illinois, when the gentleman in California died, his obit was a large write-up in the Wall Street Journal. So clearly, he was a mover and shaker. He came to me and he said, I really need to do something about my mother-in-law. And I said, well, tell me what you mean by that. And he said, well, a few years ago, we moved her out of Chicago area because it was just too cold for her. She has very bad arthritis and she wasn't getting around well, and she likes to be independent, and there's so much winter and nastiness there that she just couldn't do it. So we picked her up and we moved her to Arizona. And he and his wife lived in California. And he said she went there first to visit and found that she loved it. So she's in a retirement place, but it's very independent living, and she's happy as a clam. And he said, but the reality is all she has is her Social Security, because, well, that's just the fact. And her Social Security is just not enough for her to live on. So I need to find a way to do something. And I've been gifting to her, and my wife's been gifting to her every year. But he said, I'm just not sure that's enough. And he said, so while I was here with you and we were visiting, I wanted to ask if there was something that you thought might be a better way to fund for her. And he said, you know, we fund to the grands and the great grands like you've taught us, and we know all that, but we just don't know what to do about this, my mother-in-law. And I said, okay, well, I know he has charitable intent because I'm aware of how much he gives. So what I said to him was, is there someone in a charity that you would like to give money to that thus far you have not given money to? Or is there a charity that you would be willing to try to benefit as a part of this plan for your mother? He said, yes. He said, I really need to make a gift to I can't even remember anymore. It's a long time ago. But he said, they've supported my research at the university, and it's my hope that I can leave some money to them. And I said, okay, well, here's the first thing to understand. It's fine to do gifting to your mom, but what you're doing is you're gifting to her X number of dollars a year, we'll say it's the max, so that's probably 10,000 from you and 10,000 from Mary. But I said those are after tax dollars. So you've already paid close to 50% tax to get to the 10, which means your gift and Mary's gifts are basically costing you 30,000 instead of 20. And he said, yeah. Are you just trying to irritate me, or have you got an idea? And I said, well, yes, I was not trying to irritate you. I just want you to understand that gifting is a great tool. But if you're willing, we could establish a charitable remainder trust and name the charity of your choice. We could fund the trust with very low basis assets, because you have some assets in your trust from your dad that have almost no basis at all. We could put them in at their fair market value. They have no basis to speak of, but in essence, the charity owns the principal of this account, so there won't be immediate recognition of the capital gain. And then we could structure it so we could provide for your mother-in-law slightly more than you're providing for her now, or even more than that if you want. I said the other question I need to know is, do you want the amount that you're giving your mother-in-law to be set at a certain point that we can identify today? Or do you instead want it to be able to be raised if her needs go up? He said, oh no, whatever it costs for her to stay where she is now, that's what we want to do. And we also know she may outlive us all, because he said, neither my wife nor I anticipate living huge, long lives. But this woman is 83 and probably in better health than any of us. I said, okay, better yet. So I said, let's set up a charitable remainder unitrust. A unitrust means we'll pay a specific percentage of the value of the trust to your mother-in-law every year. But if that number isn't big enough, you can add additional principal. And when we revalue for that extra amount, we can raise what we give to your mother-in-law. So you can provide her a life estate on the money. And here's the other cool thing. Even though this is a gift to your mother-in-law indirectly, it's also a gift to charity. And your mother-in-law has the present interest, which means, guess what? She gets to use the gift you're giving her as though it were a present interest gift. So when we value this, the first 20,000 of what you give her this year will qualify as a gift of present interest based on what you've put in the pot. This is a win, 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 win. You use up capital gain property at no tax. You get your mother-in-law the money she needs without gifting directly. You provide to the charity that you say you want to provide to at her death. You also can make this last no matter how long she outlives her life expectancy on the chart. And you protect your sons, if something happens to you or your wife, from having to look after their grandmother. So that's how a charitable remainder trust works. At the end of the term, the charity gets whatever's in the pot, and likely it may grow over time. There are also annuity trusts. Annuity trusts are a set flat number of dollars that never go up or down. They're better for some people who like to know consistently what they're going to get. A charitable lead simply replaces the parties in the opposite position, so that now the charity gets the income. It's usually an annuity so that we can lock it at a number. And at the end of the term, which it might be 10 years, 15 years, your grandchildren or your children get the money. So it's a wonderful tool, specifically referred to as a split interest trust, in which one share is charitable, but the other share is not. And it leads to many creative opportunities in giving. The benefits and trust that you have for clients as you help them plan for the future are multitudinous, and this is not a complete list. But I think that if you think about the things we've talked about today and think about what things you were hoping we were talking about today, you'll know if there are other things you might want to learn. But I would say that this list of 7 things, which you can read for yourself, constitutes a good portion of the benefits people can achieve through the use of trusts and still maintain with you their asset management. So trust assets avoid probate. They can provide tax benefits, not initially, because a revocable living trust is taxed through to the grantor, but over time, many tax benefits. Trusts offer specific parameters for the use of the assets that are given. So if you want to ensure that your assets are not used for certain purposes, not given to children or grandchildren who may be habitual drug or alcohol abusers, you can do that through a trust. A Rev trust is something that, in my mind, lets individuals live longer, more independent lives than any other technique they can employ. It lets them remove all the pieces of the financial work and the worry from their shoulders and allows them to enjoy their life much better. They can help during illness or disability, not just at death. A testamentary trust is fine, but by then you've gone through all of life. They protect assets, they are very private, and they can help to eliminate family feuding by providing direction on how to distribute the assets and property, letting people in younger generations understand the responsibility that great wealth has and how and when and why you've made the decisions that you've made. So that's the end of what we were going to speak about today. I don't know if you have any questions. I certainly hope if you do, you will ask them now. Amanda, have you gotten anything that you want to ask?
There's no questions currently, but we will give time if people want to ask any questions. But if not, we can end here. We thank you all for your time and look for our next upcoming webinar. And that should be posted with dates and subject shortly. Thank you again, everybody, for your time.
Thanks. Bye, guys.